There is a reason why they say justice delayed is justice denied. Viva Frei, Montreal litigator turned YouTuber, and a while back, like way back when, before I even did these things called vlogs, I did a video entitled The Last Trial. I'll link that video right here. Give it a watch if you haven't already seen it. This is the eve of what stands to be my last trial as a commercial litigator. 10 years I've been a commercial litigator. I have a small one-day trial tomorrow. One of my subscribers asked me to do a video on what it's like to be a lawyer. I'm not going to have many more opportunities to show what it's like to be a commercial litigator, so I'll just do the last one. Can we see this? The Civil Code. I am doing a residential lease dispute tomorrow. My last trial, one day, is a residential lease dispute. Small stuff, meaningful, as stressful as the big stuff. What does it mean to be a lawyer? Paper. That was supposed to be my last trial, but law is something like the mob. Every time you get out, they just pull you right back in.
Just when I thought I was out, they pulled me back in.
I actually had another file which predated the file that was to be my last trial, but we had not yet scheduled a trial date for that file. The trial that I have is scheduled for 1 week. It was scheduled 2 years ago, and the proceedings at issue were filed in 2015. When I say that litigation is a long, soul-crushing, wallet-crushing process, I mean it. This file has been looming over my clients' heads and bank accounts for over 5 years. And when I reference the cost of the trial, it's not to illustrate how much a lawyer is going to charge for the file, it's to illustrate how much the trial is going to cost the client. I have actually had clients tell me that I need to charge more so that people take me more seriously as a lawyer. It is objectively crazy. Lawyer rates are objectively crazy. But just to put this into perspective, at an hourly rate of $250 Canadian, for a lawyer with over 13 years experience, I mean, that is cheap by industry standards. That is cheap by industry standards, but that is still $2,000 a day for every day of trial. And that is operating on the basis that I am capping it at an 8-hour day, which is a gross understatement, because a day at court is easily 12 hours of work. You have your 8 hours at court itself, but then you have your hours of prepping and your hours of summarizing when you get back home. One cannot just get back home from court and go to bed. They need to take notes and summarize what happened that day so they don't forget for the next day. And they also need to prepare for the next day. But even capping it at an 8-hour day, that is $2,000 a day for a day at court. And as far as the industry goes, typically it is 1 day of prep for every day of trial. So if you have, say, a 5-day trial, that is going to be $10,000 for the cost of the trial and $10,000 for the prep for the trial. And that's if you're fortunate enough to have a cheap attorney by industry standards. $20,000 to have a 5-day trial if you have a cheap attorney and nothing gets out of hand in the context of that trial. And that doesn't even include any appeal. I've explained the litigation process in detail in a previous vlog. I'll link that video right here if you haven't seen it. Give it a watch, it's a good one. Litigation begins when there is a dispute between two parties and they are no longer really speaking to each other. That's why they have to go get lawyers. Let's just take the most textbook example of a dispute. One neighbor cuts down the other neighbor's tree while the neighbor's at work. The neighbor goes over and says, "Why'd you cut my tree down?" The other neighbor says, "It was leaning over my property, the tree was dead, it was gonna fall over and hurt my wife and kids." The neighbor says, "You had no right to do that, I'm gonna sue you." And now they're no longer talking. And neighbor A goes to find a lawyer and says, "Neighbor B cut down my tree. That tree was 150 years old. It was beautiful. It added property value to my property. My great-grandfather planted that tree. It had some special meaning to me that you can't even quantify with money.
I want to sue him."
And also, don't forget, that's $20,000 for the 5-day trial and prep, but that doesn't include all of the costs already incurred in the court file. We are approaching the trial in this file, but this file was instituted in 2015 and has already gone through an amazingly complex litigation process at tremendous cost. I have no doubt that some people are going to be shocked and blown away by the judicial delays that I am describing in this video. From what I understand, the process moves much quicker in other jurisdictions. I don't know of any jurisdiction where it moves much slower, but at the very least in Quebec, it's no less than 6 months to get a trial date and sometimes upwards of a year or 2 years. And that's after the parties have gone through the litigation process itself to get the file ready for trial. I've said it before and I'll say it again, the process literally destroys people. This is not something that I've talked about, and I'm not sure that I ever will talk about it anymore, except to say that in the context of this litigation process, I have had more than one client take their own lives, and it is something that has traumatized me to my core. The process is long, it is costly, and when they say justice delayed is justice denied, there is a reason for that. So I am now preparing for a trial that is coming up in a month or two, in a file that was set for trial 2 years ago, that was instituted 5 years ago. And the process of getting back into that file and preparing that file for a trial is something that I said I have to make a vlog on. Alright, only parentheses of this entire video. These days I've been doing a lot of current event vlogs, breaking down something that's going on in the news and explaining it in terms that non-lawyers can understand. I have done a ton of what we call evergreen vlogs. I did the last trial. I've done a video explaining how to prep a witness. I've done a lot of videos explaining what the day-to-day life of lawyers is like. I did a vlog on how to survive law school, on what being a young lawyer is like, on what being a lawyer is like at large. Much of these videos were done when I had like 10 to 20,000 subs, so a lot of you probably have never seen those videos. Take a few hours to go back to my really old stuff to get a feel for what, it was like to make cringy law videos. I think I hear my wife behind me. I don't. Back to the video. Think about what goes into getting back into a file that has literally been sitting on a shelf for 2 years. You gotta pull that file out of the cabinet, dust it off, and reread it. You gotta re-immerse yourself in that entire file, but before you can even do that, you have to start thinking about witnesses. And I'm not talking about preparing witnesses, examining witnesses, cross-examining witnesses. You need to make sure that you get your witnesses to trial. You need to issue subpoenas to those witnesses. Now, depending on your jurisdiction, there are minimal delays of advanced warning that you have to give a witness by law. You can't serve a witness with a subpoena the night before the trial and expect them to be there. So 3 months before this trial, I start sending out subpoenas to make sure that I'm not going to have any problems getting the witnesses we need to show up for trial. But sure as sugar, problems arise. Witnesses who were available several years ago might not be available today. In my specific case, I actually found out that some witnesses have died. So you got to locate your witnesses, get their addresses, and then validly serve them with a subpoena to compel them to show up to the trial. And then you got to think expert witnesses to the extent that you have any expert witnesses in the file. The expert that you had prepare a report in your file 2 to 5 years ago may not be at the same place of business. He may not even be on the same earth anymore. So you gotta find your witnesses, serve your witnesses, and then you gotta prep your witnesses. But before you can prep your witnesses, you gotta get re-familiarized with the file. And there literally is very little that you can do to remain familiarized with a file when you haven't touched it in 2 years. You can write your executive summaries, which is a very good idea just in case you are not in the file several years down the line. Because I have literally been in files where the lawyers have died. And when the lawyer dies, especially spontaneously, if they haven't put executive summaries in the file, a new lawyer is going to have a rather sharp learning curve. But rereading your own executive summaries is only so good. You need to refamiliarize yourself with the entire file, all of the proceedings, all of the exhibits, all of the expert reports, all of the opposing parties' proceedings, all of the opposing parties' exhibits. You have got to reread the transcript of the deposition that you yourself conducted a lifetime ago. And when I say a lifetime ago, I'm not saying it to be poetic. 5 years is a long time. Try reading your diary from 5 years ago to see what you were thinking a half decade ago. Rereading your own proceedings 5 years later when you have 5 years more knowledge, experience, etc. Sometimes it's a little embarrassing actually. But I've got to say, at the very least in this particular file, I am rereading through the proceedings and I am not embarrassed to read them. They are actually still well drafted 5 years later. And incidentally, if my colleague with whom I was working at the time is watching, thank you very much. I know you drafted those proceedings. They are awesome to read 5 years later. But it is a process to get back into a file that has been sitting on a shelf for 2 years. It is a procedurally and monetarily inefficient process. Justice delayed is justice denied, not just because people don't get a resolution to their dispute, but also because in order to get a resolution for that dispute, it ends up costing the parties twice as much as it should. So you've got to remaster proceedings, exhibits, transcripts. You have got to remaster the case law and the research that you did 5 years ago because presumably you did case law search when you took the file. Presumably, if you are a responsible attorney, you did the case law and legal research at the time so you knew how to conduct the file. Like I've said in previous vlogs, in order to conduct a file well, you have to have an understanding of the law in order to know what questions to ask and what evidence to seek. So you have got to remaster all of it. And while it's not like starting from scratch entirely, it is certainly not starting from where you left off years ago. And then once you have remastered yourself with the paperwork in the file, then you meet with your witnesses, you prep them, you go through their testimony, you go through your examination outlines. You coordinate with the witnesses to see who testifies when, who goes before whom. And then you've got to prep your cross-examination of the opposing parties' witnesses. A day of preparation for every day of trial, even though most attorneys know it's going to be more like 2 days of prep for every day of trial. And the week before the week-long trial is dedicated exclusively to that file. It's not a time when you can be distracted with other files. It's really not a time where you can be distracted by anything else at all. Trials are all absorbing, and I've noticed that when I'm in trial, I typically lose about a ½ pound a day per trial. Capped at about 7 pounds. When I was in that 18-day trial, I didn't lose 18 pounds. I did lose 7 pounds, however. You're not sleeping as much, you're not eating as much, you're getting up early, you're going to bed late, and you end up losing weight. In fact, it might be the most effective weight loss program out there. If you want to lose weight, just go through a horrible, stressful trial. Alright, so I hope I have shed some light on the process that goes into getting back into a file and prepping for trial. It is a headache, a stressful headache, a costly, stressful headache. And the longer it takes, the more of an injustice it is for everyone involved. With that said, if you like my videos and you like my content, be sure to like, share, subscribe, hit the notification bell, which turns on notifications for all of my videos. I have a second channel called Viva Random where I post the random videos that I used to post on this channel before I became the vlog guy. The video I just posted there, for whatever the reason, is wildly popular. I posted it to Twitter. It's my most popular tweet ever. We'll link that video right here. Give it a watch. It's a good one. And now you know you vlog. Peace out. Booyah!